Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody. Welcome to our 2024 Virtual HOA Condo Academy class number 8. Today is Tuesday, August 20th, and we're going to be talking today about what is a community association and what are the secrets of successful associations. I can see right now that we've got a number of people joining us, so welcome everybody. As I said earlier, our topic today is going to be what is a community association and what are some secrets of successful associations. Remember, your community association is a business, a nonprofit corporation governed by your association's documents, which are referred to as the CC&Rs, the Articles of Incorporation, and the bylaws, also the rules. In this class, we're going to give you an overview that will define different types of HOAs. We'll talk about what the different types of documents are. We're going to talk about the organizational structure of these associations and rights and responsibilities of board members and homeowners. Lastly, this class is going to provide tips and tricks to effectively run your board and everything you need to know to have a strong and effective board. So good morning, everybody. I know we have a number of you joining us here today. Looks like oh my goodness, we already have 131 people, which is awesome. Welcome to class number 8 of our firm's 2024 Virtual HOA Academy, Condo Academy. We teach these classes or this academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Our common goal has always been to provide free education to board members, homeowners, and managers so that you can more effectively run your associations. My name is Beth Mulcahy, for those of you who may not have met me before, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed working with associations for over 27 years, now almost 28 years. And my firm currently represents as legal counsel about 1,000 associations, or just over 1,000 associations throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. We're running this class today just like we've always run other classes. Feel free to submit your questions in the Q&A box on Zoom and or in the comments section on Facebook Live. All questions will be answered at the end of the session, so likely right at noon. Friendly reminder, today's session is limited to one question per attendee. Thank you for understanding. Before we get started with our presentation today, we launched our poll a little bit early today just so that you would have an opportunity to participate and read through the questions. But I like to always have a poll at the beginning of the class because I like to know who's here. I want to know how many board members we have, how many managers, how many homeowners, so that I can best tailor the presentation to my audience. I also like to know which cities are represented here today because I provide feedback after every class to the different cities that we partner with to teach these classes, so they're aware of how many people from their cities are attending the classes. Okay, so as you can see on your screen, we have 2 polls that are launched at the same time. Again, if you're joining us on Facebook Live, just put your answer in the comments section on Facebook Live and we'll factor that into our results. The first question is, which city do you reside in? So whatever city your HOA or condo in Arizona is located in, if you could put that in the poll, that'd be great. And then let us know your current role, which is the second poll. And it looks like we already have some of our results are coming in. So while we're waiting for those, I want to talk briefly about the Arizona legislature and some federal laws that you need to be aware of as we navigate to the next few months. A quick update on the Corporate Transparency Act. We have a great handout that our firm is going to be sharing with you here shortly, if we haven't already, on the Corporate Transparency Act. Just a quick overview would be it's a federal law that was passed by the United States Congress to better crack down on terrorist activities. It's kind of crazy that associations, condos, and HOAs throughout the United States are subject to this law. And there's been a bunch of efforts, litigation and new legislation that have been underway to carve out HOAs and condominiums from having to comply with this law. So a couple things that I want to just mention. As of right now, you do need to comply with the law. And how do you comply with the law? We need to file some informational paperwork with the federal government before December 31st, 2024. Our blog that we're sharing with you, or we'll be sharing with you shortly, lists all the different types of information that we have to provide regarding a key contact person for the association and also the board members' contact information and other information. I'm a board member. I'm going to have to comply with it too. I don't feel that it is overly intrusive. The government already has this information likely, so it's nothing new. It's just an additional burdensome step that all associations need to comply with by December 31st, 2024. So by December 31st, 2024, we have to file the paperwork with the federal government. Okay, a couple thoughts. First, our firm is providing a service where we are helping associations comply with this new legislation. We have a flat fee to help associations, so reach out to our firm if you need assistance with getting this paperwork filed. Kind of the key thing on this paperwork is that it has to be updated anytime there's a change in the information that's submitted. So if a board member changes or the management company changes, we have to update within a timely manner. So this is like an ongoing reporting requirement that we're going to have to do. We thought long and hard about what the fee for this is going to be, but it will be $350 is what we're planning to charge. I know that there are a number of other management companies and other law firms that have a different structure to help you with this. So feel free to use whoever you want. I just wanted to give you kind of a price point as to what we're planning to charge. In order to meet the filing deadline, if you can contact either our firm or whoever you plan to help you with this by November 1st, I think that would be a good safe time that you will still be able to get this filed by December 31st, 2024. If you have any questions about the Corporate Transparency Act, you are welcome to reach out to our firm at info@mulcahylawfirm.com. I get this question a lot, so I'm just going to answer it right now. Do you think that there's going to be legislation prior to December 31st, 2024 that will carve out or take out the HOAs and condominiums requirement to comply with this new law? I don't think there's enough time now, honestly, to have that happen. It may happen, later in 2024. The second question that I get is, do you think that there will be a case that will be decided that will carve out HOAs and condominiums? And right now, there's a case, a different company by the name of the National Small Business Association that has litigated this issue. It's currently on appeal. The ruling in that case was that the Corporate Transparency Act was unconstitutional. However, it only applies to that particular organization, the National Small Business Association, and associations, HOAs and condos, aren't included in that lawsuit. I know that Community Associations Institute, which is a national think tank, has filed an amicus brief, which means like a friend of court brief with that case, supporting the unconstitutionality of the Corporate Transparency Act. I know I read something recently that Community Associations Institute, again, national think tank that works with associations, is hiring an attorney and is going to be filing their own lawsuit to deem this Corporate Transparency Act unconstitutional for HOAs and condominiums throughout the United States. So stay tuned. But the bottom line is, I was hoping that we wouldn't have to comply with this, meaning HOAs and condominiums wouldn't have to comply with this before the deadline of December 31st, 2024, but we're running out of time. So I think we do have to comply with it, at least for this year, and then take a wait and see approach. So keep your eye on that. Have that on your tickler of things that you need to keep an eye on and make sure that you're complying with that before the end of the year this year. Okay, let's flip back and look at our poll results real quick, and then we'll talk a little bit about the Arizona legislation. So we had 2 polls today, and we had a really good turnout of people from different cities today. Which city do you reside in? We had 8% from Chandler, 7% from Glendale, 5% from Goodyear, 25% from Mesa. Great job, Mesa. 9% from Peoria, 16% from Phoenix, 14% from Scottsdale, and 10% from Surprise, and 5% from Tempe. Looking to our other poll question, how many of you are board members that are joining us here today? 65% are board members, 12% are community managers, and a whopping 21% are interested homeowners. That's higher than normal. So great to see so many different groupings of people here today that are interested in their associations. Let's switch gears and talk a little bit about the 2000 legislative update for Arizona. We're really kind of getting into the final countdown in terms of when these new laws are going to be going into effect. Arizona, the new legislation for the bills that pass this year are going to be going into effect on September 14th, 2024. We're going to be designating a substantial portion of our First Fridays free call-in in September to answer all of your questions on the new legislation. We're also going to do a quick overview of what you need to know about the new Arizona legislation that'll be going into effect mid-September. Here are the most important things you need to know about the new Arizona legislation going into effect on September 14th. And again, this is just a quick overview at 30,000 feet of, okay, here's what you really need to know. Transfer fees. There was a new law this year that talks about when transfer fees can be charged, and it has a very, very narrow alley that we are talking about on this. This is in no way changing transfer fees in any other way, except that planned communities and condos cannot charge transfer fees or capital contribution fees when only nominal consideration is paid and it's between family members or business entities. So let's give a quick example. Let's say that your association has a transfer fee provision in its CC&Rs and it complies with this new law that talks about what we need to have to make it, compliant with state law. It has to be in your CC&Rs, it has to touch and concern the land, etc. But let's say that your association has a transfer fee provision in your documents. And let's say that I am selling my property between myself and my son or my daughter. And it's basically, we're just doing it for estate planning purposes or something like that. The association cannot charge a transfer fee from me to my son if there's nominal consideration and it's like an interfamilial transfer. This also extends to interbusiness transfers. Like, let's say that you are transferring it from one business to another business and they're related in some way. Also, estate planning purposes would be a great example if you're putting my property into a trust, etc. So they're limiting the scope of how often you can charge a transfer fee when there's little to no consideration and when there are these intricate relationships between the parties. The second law that I want you to know about is this applies only to condominiums, and it talks about improvements that may disturb other residents. So if you're living in a condo and you're on the bottom floor and there's a resident that's living above you on second floor, this is going to apply to you in a condo. So if an owner makes an improvement or alteration that may disturb its neighbors, let's say the neighbor on the second floor decides to put in hardwood floors, and that may disturb the neighbor downstairs, right? The condominium association cannot prohibit it as long as the owner purchases, installs, and pays for anything necessary to eliminate or minimize the disturbance. So in my example, typically if somebody's going to put in flooring, they'll have some sort of subflooring to help eliminate the noise that might be traveling down below. Like there's special cork that you can use, and all the flooring companies are very familiar with those noise abatement type situations. Okay, the next one that we're going to talk a little bit about is on collection of assessments and other amounts owed. This applies to both planned communities and condominiums. There have been some updates this year in terms of how we can collect unpaid amounts that are due to the association. One change is that prior to filing a foreclosure against an owner, we have to make reasonable efforts to communicate with the owner and offer a reasonable payment plan. And so what a lot of our clients are doing is they're just changing their form letter that they send out when they contact owners regarding delinquencies. And the form letter is changed in such a way that we're offering a reasonable payment plan as part of that form letter. And they have an opportunity to accept that if they follow the instructions in the letter. A couple things, other changes on this law is the type of things that we can lean for now under Arizona law and the planned community and a condo have changed a little bit. So no matter what the documents for your association state, this association new legislation is going to apply to planned communities and condominiums. And basically the changes that fees and charges like self-help fees or charges charged to an owner, for damage that they may have done to a common area, late fees and fines and penalties can be collected under the common expense lien only via a civil lawsuit and once a judgment is obtained in a civil lawsuit. And so a couple things to think about on this would be really we can only now, lien for the unpaid assessment. And, we want to be really careful that we are following when we're doing the liens. Most management companies are doing the liens, so they should be doing this correctly. Late fees are no longer going to be secured by the assessment lien, so we can't just add those late fees onto the lien that we record. Prejudgment interest is expressly excluded from the lien. If attorney's fees and costs have not been awarded by a court, we also cannot include that in the common expense lien. Any payoffs that we may have to release a common expense lien cannot include fees, charges, or fines not covered under the common expense lien unless they are awarded by a court. However, these amounts will remain the personal obligation of the owner. So this is going to be a change for how we handle delinquencies and collection matters. We have to apply payments that are made by owners in a certain way without any direction as to how they should be applied. Is that the biggest change here is that we have to apply when an owner makes a payment, it's going to go to the most past due assessments that are due. That's kind of something that we've done previously, but you couldn't, like, let's say you have a law firm that you're working with and they sign a separate agreement, payment plan or something with the owner saying, any payment you make, all the money goes to the attorney's fees first. Our firm doesn't do that, but I have seen other firms doing that. That's no longer allowable. We have to follow specifically what the state law says, and any payments that the owner makes are going to go first to pay the unpaid assessments. Another kind of unusual part of this new law is that associations cannot sell owners' debts to a third party. I hadn't really seen associations selling debts previously, but somebody must have been doing it because there's a law on it. So bottom line on the collection of delinquent assessments and other amounts owed to a planned community or condo is it's changed a little bit. We can really only lien for the unpaid assessments. We cannot lien automatically for late fees, interest, attorney's fees that haven't been awarded from a court. And it's going to change just a little bit how we do things. Our form letter is going to have to be tweaked a little bit so that we offer a payment plan prior to proceeding forward with the foreclosure. And those are kind of the biggest changes. I think it's manageable. I wish that we didn't have this law this year. This is not what I would call favorable law, but it's manageable. A couple more new laws that I just want to make you aware of quickly would be we have to give an agenda for any board meeting now. We have to provide that agenda when we post the notice of the meeting. So the specific language of the law is that the secretary of the association must provide an agenda for every board meeting by posting it in the same way, that we put the notice out there 48 hours in advance of the meeting. So when you're posting your notice of meeting, you need to be posting the agenda now too, as part of that notice of meetings. And that is going to be starting September 14th. There also is a provision on declarant control and how we compute that. I'm not going to go into that because it probably doesn't apply to most of you, but just be aware that there is a declarant control clarification that makes it very clear when the period of declarant control ends, etc. There was a law this year on mounted flagpole holders, which is kind of a weird law, but basically it says that associations may limit an owner in a planned community or a condo to 2 wall-mounted flagpole holders. And just a clarification on that, on the flagpole holders, that's just for planned communities, not for condos, because the condo would own the outside of the condo and not the owner. So if you live in a planned community, you can have 2 wall-mounted flagpole holders. The next bill talks about fair housing violations in CC&Rs. It applies to planned communities and condos. This has very limited scope. Basically, if you have language in your CC&Rs right now that violates the Fair Housing Act or is discriminatory, it allows the board or a group of owners to take that language out. I really don't see that very often, and I don't see that as an issue that comes up very often, but just be aware that if you may have something in your documents that's discriminatory, that there's a remedy that doesn't require a vote of the membership, that we can just pull that right out. Another important thing that we should talk about are casitas. We're seeing a lot of articles about ADUs and casitas. And so alternate dwelling unit is the ADU is the slang for that. Basically, I just want to make it clear that this only applies in a limited way to associations. So what this law says is that it limits a city's, town and municipality, county's ability to restrict short-term rentals, right? but it doesn't supersede or trump our association documents that may put restrictions or limitations on ADUs or casitas. So no matter what the state law says, it restricts the city from doing anything about these or making rigorous rules on them. It doesn't apply to associations in that we can have more strict rules regarding the casitas or ADUs. And so it's very, important that you're aware that our CCNRs would trump in that situation. Let's see, chicken coops. So we also have seen some legislation this year on chicken coops. Basically, this says that municipalities cannot have stricter prohibitions on backyard chickens than specified in this bill. Municipalities cannot prohibit owners of a single-family detached dwelling from maintaining up to 6 chickens. The chickens must be enclosed in a coop. There are some setback requirements that are put out there. Roosters are still prohibited. Chicken enclosures must be cleaned twice a week. And it really, again, this is just like the ADU casitas thing. It does not impact an association's ability to have restrictions in their CCNRs on chickens. Now, the impact is that maybe in the past we were able to go to the city and make a complaint through the code enforcement department if we had a chicken coop problem or a chicken problem. That's going to change a little bit. Now we really need to rely on our enforcement and our documents. So that's just kind of a quick little update about what's going on here. Also, we're going to be talking at the first Friday next week in a couple weeks, the first Friday in September. We're also going to be talking about the legislation from last year where certain associations that have streets that are dedicated to the public or the city, town, or municipality, if the association still wants to enforce the parking restrictions, even though the streets are like city-owned or dedicated to the public, we need to take some action here in 2025. So we're going to be talking about that bill as well in our first Fridays that we're going to be having the first Friday in September. So I want to make sure my team remembers to add that to our topic of discussion too. Okay, let's talk about our main topic for today, which is going to be what is a community association? And I'm wondering maybe if this topic that we publicized maybe encourage more homeowners to come today because we had a higher level of homeowners. So really glad to see all of you here today. I think it's really important for us just to do a quick overview of, what exactly is an association? What are the different types? What laws apply to them, et cetera. So just some introductory information. There are about 10,000 associations in Arizona right now, which is crazy. That's a very high amount of associations. I belong to a lawyers group where we, share information about legislation. We talk about issues, and we always kind of go around the room and talk about how many associations we have in our respective states. And everybody is always shocked when they hear 10,000 because maybe they're in Massachusetts and they only have, 3,000 in the entire state or whatever. And so I think, why is it that Arizona has so many HOAs and condominiums? Well, remember, we're kind of in the Wild West, right? And Arizona developed much later as, in terms of widespread development, real estate development, much later than maybe other parts of our country. And as part of that development, it was a very common business plan to have, a city, town, or municipality require that the developer make an HOA or a planned community so that it would support the infrastructure within the community, like the roads, et cetera. What are some common characteristics of a community association? So one thing that's kind of unusual, I guess, would be, hey, I love this house, right? I want to buy this house. It's so cute. As soon as I become the owner of a house in an association or a condo in a condominium association, and I accept the deed to that lot or unit within that association, I'm now just signed a contract to be bound by the terms of the contract and the governing documents, which is the contract. And those are typically like the CCNRs, the articles of incorporation, the bylaws and rules and regulations for the association. Those create obligations on the part of the buyer, now owner, and also on the association and its board. most community associations, just so you know, are set up as nonprofit corporations and are subject to the laws affecting profit corporations. The main laws, though, that we apply to, we're going to talk about in a minute, are going to be typically the Planned Communities Act and the Condominium Act on a state level in Arizona. We use the Nonprofit Corporation Act rarely and only in times where we need to fill a gap, or we can't find the answer in the Condo Act or the Planned Communities Act or the association's documents. And then we flip over and we look at what does the Nonprofit Corporation Act say about a certain thing. And kind of a real common time that we do that would be on quorum. So if there is no quorum requirement in your documents, oftentimes we will look at the Nonprofit Corporation Act for that, and there's a default quorum of 10% of the membership. Okay, let's switch gears and talk about what are the different kinds of associations in Arizona. There really are two main types of associations. So you're either a condominium or you're a planned community legally in Arizona. And our firm has a really great cheat sheet on what is an association. So a lot of what I'm teaching here today is also summarized in that cheat sheet. So my office will be sharing that with you as part of this, or you can always find it on our website at mulcahylawfirm.com. Okay, so two types of associations. How do you tell them apart? A lot of times clients will say to me, well, I can just look at it and I know that's a condo, that's a planned community. And I mean, generally speaking, yes. I mean, if it's a 4-plex or a 6-plex or an 8-plex and it's 3 stories high, right, it's probably not going to be a single family home, right? But there's actually a more detailed way of looking at the difference between a condo and a planned community. And it's completely set up in the Planned Communities Act and the Condominium Act. And so I want to talk about what specifically makes something a condo and what specifically makes something a planned community. So here's the trick. So if you don't know what your association is, here's the way to tell. So if you're a condo, each owner owns their unit plus an undivided interest in the common areas. So for example, if you live in a 100-unit condominium and you own unit 1, you own unit 1 plus a 1/100th interest in the common areas. In a planned community, it's a little bit different. The individual owns their separate lot, and the common areas are owned by the association as the corporation entity, not in an undivided interest way with the owners. And so, that's kind of, there's a very detailed, summary under the law, but that's just the easiest way to do it. So in a condo, you own your unit plus a percentage interest in the common areas. Planned community, you own your lot and the association owns the common areas. Okay, if I get a question from a client, what are we? Like sometimes I'll get a question like a townhouse. That's always like a tricky one, right? Because Arizona law doesn't recognize townhomes. So even though you may have, your association may be named ABC Townhomes Association, guess what? You're either a condo or you're a planned community. And Arizona law doesn't recognize townhomes, even though your documents may call it a townhome. So if I get that question and we're kind of unsure, what are you and why is it important? Because there's different laws for different entities, different laws for condos versus different laws for planned communities. So if I get the document and it says Townhome Association, how do I figure out which category they fall in? Really the first thing I do is maybe I'll look up a deed of an owner that lives in the association. Typically it's going to be a board member because they're usually the ones that are contacting me. And I'll look at what the deed says, the warranty deed. And, it may say that Johnny Appleseed owns unit 16 plus a 1/200th interest in the common areas. Well, then that's probably going to be a condominium. This association is likely going to be a condominium. If it says Johnny Appleseed owns lot 4, well, and no mention of the common areas, they're probably going to be a planned community. That's one place I check. Another place I check is I get the CC&Rs out and I look at the definition section. And I look at, the common areas, common elements section in the definition section, and I see who owns those. Is it does the association own it? In that case, they're a planned community, or do the owners of, the undivided interest in the common areas, do they own the common areas? And it's going to be a condominium. I know that's kind of confusing, but why is it important? Because you have to know which laws apply to you. And there are different laws for condos and different laws for planned communities. And you want to make sure you're in the right lane, for your association. Okay, so and remember, if you're called a townhome in your association's documents, we got to just decipher, are you a condo townhome or are you a planned community townhome? Because townhomes aren't recognized. Okay, let's talk quickly about what are the legal documents that regulate an association. So why is it important to know this? It's important because all of these documents apply to your unit or lot and your association. And so you want to understand what their role is and where you go to look for answers if you have questions regarding your association. So really the documents, I'm just going to do a quick summary of them, and these are all listed on our cheat sheet, but the summary is the plat at the top, the CC&Rs or the declarations second, the articles of incorporation third, bylaws fourth, rules fifth. So again, plat, CC&Rs, articles of incorporation, bylaws, rules. Sometimes we have a conflict between the documents. Like maybe the CC&Rs say there should be 3 directors, and maybe the bylaws say there should be 7. We go back to the hierarchy that I just talked about. Whoever's higher up in the hierarchy prevails, trumps. So plat, CC&Rs, articles, bylaws, rules. In the example I gave you, the CC&Rs would prevail. It'd be 3 members should be on the board. Okay, let's talk a little bit about what these different documents mean. So the plat is just like a huge map for your association. It's actually kind of cool to look at. And it outlines where all the lots or units are in your association. Usually it's kind of pretty. It's got like a real detailed, view of your association. And it's not like a pretty picture in that it's colorful. It's just a legal document that just lists the units like 1, 2, 3, 4, and then it also lists the common areas. And it defines, where the easements are for your association, et cetera. Typically, that's the first thing that your developer filed and got approved with the city, town, or municipality that you're in. And then that's recorded. And that's kind of one of the first documents that your developer did for your community when they were creating your community. So important to the plat is that it outlines where the lots or units are. It talks about where the common areas are in the community. It has important notes usually in the upper right-hand corner that talks about different things like easements, et cetera, in your association. The next document is the CC&Rs. This is the kind of the most important document that, in my opinion, I go to the CC&Rs usually first on most things. And these are the restrictions that run with the land and are binding on all current owners and successive owners. So this is the document when you find that adorable house that you love somewhere in Arizona and you decide to buy it. This is the document that you really can't negotiate, right? You get what you get and you don't throw a fit. And so whatever you're buying in this association, you get this CC&R as part of that transaction and you can't negotiate it. It is what it is. So, most CC&Rs are very reasonable and there's no issues, but CC&Rs are going to talk about what the association's required to maintain, what the owner is required to maintain, what type of insurance the association and the owners respectively have to have, the obligation to pay assessments, use restrictions, like you can't have, a clothesline with laundry on it or no sheds or, whatever the use restrictions are. This document is recorded with the recorder's office in whatever county you live in. Most of you probably on this call are in Maricopa County or Pima County. And you can always find a copy of it online, which is great. Also, most associations have their documents listed on their website, which is also a great idea. Okay, so that's the CC&Rs. The kind of slang for it would be the declaration. CC&Rs, it stands for Declaration of Covenants, Conditions, and Restrictions. Okay, the next document we have are the Articles of Incorporation. The Articles of Incorporation are the document that sets you up as a nonprofit corporation, your association up as a nonprofit corporation. Why do we do that? To limit the liability of the corporation and its members, the owners. It's filed with the Corporation Commission at the earliest stage of, your association. And by the developer, typically, you have to file an annual report every year to stay in good standing with the Corporation Commission. And usually, we don't really go to the articles very often to look for things. It's a pretty simple document. So it's just you need to be aware that it's important in that you have to have it, right? You want to be set up as a nonprofit to limit your liability and the liability of the corporation and the members, because you don't want anybody, to have to pay out of pocket if somebody, trips and falls at the community pool and sues the association. We should have layers of insulation, insurance, the corporate entity around the corporation that protects the individual members and the board members from liability. Okay, next document that we're going to talk about are the bylaws. The bylaws are the how to run the association. So how many board members there should be, when your annual meeting is, what your quorum is for an annual meeting, what are the roles of the officers, what do we do if someone quits being on the board, what do we do if somebody moves and is no longer living in the community and they're on the board. It's just the nitty gritty ABCs of, okay, this is how we run the board and for our community. One thing that I see kind of often that I want to just mention is sometimes boards it's usually easier to amend the bylaws than it is the CC&Rs. Usually the CC&Rs have a little higher percentage to amend of the homeowners, and sometimes the bylaws are easier to amend. Maybe it's a lower percentage of homeowners that are needed to amend, or maybe even the board can amend the bylaws. Just want to mention something. You don't want to put something in the bylaws because it's easy to amend that really should be in the CC&Rs. So like use restrictions and responsibility to pay a capital contribution fee or transfer fee, that should be like in the CC&Rs, not in the bylaws. So you don't want to backdoor trying to get something done by putting in the bylaws, because remember, the bylaws are just the how to run your association. It's not the use restrictions that would regularly be in the CC&Rs. And then last but not least, we have the rules and regulations. Usually the board is empowered by the CC&Rs or the bylaws to create rules for your association's common areas or behavior of your residents within the community. Again, the rules cannot conflict with the CC&Rs or the bylaws for your association. If your board is ever thinking about changing its rules or creating a new rule, it's a really good idea to run it by your management company and your legal team, your law firm, just to make sure that whatever you're proposing is going to be consistent with Arizona law and federal law, and that it's not something that conflicts with your current documents, your CC&Rs. Okay, let's switch gears and talk a little bit about who are the key figures in an association. So we've briefly mentioned the developer. Many of you are probably post-developer time, but some of you may be in the development stage. The developer is also commonly known as the declarant. And this person is in control of the association during the early phases of your association. So the developer kind of creates the association, prepares the governing, they create the first budgets for the association, basic administrative procedures. They set up the association's legal records. They take their board meeting minutes when they're in control of the board, etc. Once a certain percentage of lots or units are sold, the developer then transfers the control of the community association to the owners. Oftentimes, when there's a transfer from the developer being in control of your association to the owners being in control of the association, we hear about problems. We have a great cheat sheet on that topic called Transition from Developer to Homeowner Control. You can find that on our website at mulcahylawfirm.com. It just goes over what are the most common problems we see during that development transition, and what are some different remedies that you have if you're going through a transition with a developer and you feel like they're not handling things properly. So I encourage you to take a look at that cheat sheet if you are still under developer control as your association and you're worrying about that transition from developer to owner control. The next group of individuals that I want to talk about would be the board of directors. Owners elect the board of directors for your community, unless it's the developer that's running the community. They typically appoint themselves, but post-transition from the developer, owners are elected by the board. Owners are elected to the board of directors by owners. You have an annual meeting every year, and that's typically when your directors for the board of directors are elected to serve. It depends on how long the term is. Some associations have a 1-year term. Some have a 3-year term. I really don't ever see anything over a 3-year term for directors. The governing documents for your association, which we just talked about, the CC&Rs, the bylaws, articles of incorporation, they give the board authority to act and also obligations to act. Here's some examples of some things that the board is required to do pursuant to, your association's documents. You have a duty to enforce your governing documents. You have a duty to maintain architectural control, and in some cases, especially in planned communities, making sure owners are getting approval before making architectural changes to their property. You have a duty to maintain the property as a board. Make sure that the pool is, being cleaned and that, the lawn is being maintained and the trees are being trimmed, etc. You have a duty to carry insurance, and you want to look at your CC&Rs to see what those insurance requirements are. You have a duty to provide services and facilities to members. So, I get this question from time to time. Hey, our board just chained the tennis courts shut, and they've been chained shut for 5 years because we don't have any money to maintain them. The board really needs to think outside the box in that situation and get with their trusted advisors to determine what are we going to do with this. We either need to raise money, take out a loan, or take out the amenity. And there are legal implications from, doing all of those 3 things. But you have a duty to, provide services that members, want in the community and that they expect based upon what they purchased. They have a duty to create budgets for the year. Everybody should be working on their budget right now for 2025. The next few months are going to be budget season. And then once you set your budget, then you have a duty to levy and collect assessments so that you can fund everything that you need to do. So pay your management company. How do we do that? Through assessment income. Pay for the landscaper, pay to, renovate the jacuzzi because the tile's broken, whatever. So one of the duties you have is to, create a budget, levy the assessment, and then collect the assessments. Another duty you have, I briefly talked about, is you have a duty to have an annual meeting every year where you elect directors and give kind of a state of the union about what's going on at your association, good and bad. You also have a duty to conduct regular board meetings. You have to comply with the open meeting law in Arizona. And the open meeting law says anytime a quorum of the board is present discussing association business, it needs to be an open meeting. We need to give 48 hours notice. And now, starting September 14th, we're going to have to post that agenda for that meeting when we post the notice 48 hours in advance of the meeting. Also, most importantly, the board has a fiduciary duty to act in good faith and in the best interests of the community, and with such care that a reasonably prudent person would act in the same or similar circumstances. So when you're serving on your board, you have a duty of care. You have to make your decisions, wisely, look at alternatives, do your research. You have a duty to avoid conflicts of interest. You should never, ever be benefiting financially by being a board member in your community. And lastly, you have a duty of confidentiality. You're going to get the juicy scoop. You're going to hear the juicy scoop when you're serving on your board. And what I am, reminding you of, if you're serving on your board, you must keep confidential information confidential. That means you can't talk about what you discuss in executive session with your spouse, with your friends who may not be on the board. You have to only talk about that with the board's attorney, maybe your manager. And so fiduciary duty is a very important component of board members' service to the community. Okay, so we have the board members. So let's give an example. This is kind of sometimes a little confusing. Let's say you have a board of 7 people and you have 4 officers. So how does that all work? So you have 7 elected board members, right? And then 4 of the 7 are board members and officers too. So let's say 7-member board, you have 3 directors at large and 4 officers and also board members. So what are the officers? So we have a president, vice president, secretary, treasurer. Usually your documents will outline the specific responsibilities for each officer in your community. The officers are not elected by the membership. The officers are elected by the board. So typically right after the annual meeting each year, we have a little planning meeting and everybody agrees among themselves who's going to take which officer position for the community. Let's switch gears and talk a little bit about members and owners' rights. Since we have, 24% of you here today are owners, I'm so glad you're here. What are some of your, rights as an owner, and what are some of your responsibilities? So, some of your rights are to elect board members, right? You can also run for the board yourself if you're interested to. You have a right to review the books and records of the association. So if you want to look at the financials of the association or the association's bank statement or meeting minutes for the past year, you have a right to request that in writing from your board, and they have 10 business days to get that to you. They can charge 15 cents per page for any copies that are made, or you can just go into their office and inspect them at no charge. You also have a right to due process, which means that if you are sent a violation notice and the board is threatening to fine you for a violation, you have a right to be heard. And that could be ask for a hearing or write back by email what your position is on something. So you have due process rights before a board can fine you. You also have the right, pursuant to the new law, right, under September 14th, if you have a right to ask for a reasonable payment plan. And based upon the language of this new law, you certainly have a right to ask for it and get it in return. And we would be advising all of our clients, we always have, even before this legislation, that if an owner wants to set up a payment plan and, it's a reasonable time period, like 6 months to pay it back, and they live up to the payment plan, it's a win for everybody, and we should be doing that. Okay, you also have a right to ask questions. Now, I say that with a little caveat because I don't want people to go overboard with the questions. I mean, with the volume of associations that I represent and the amount of time that I've been doing this, over a quarter of a century, it's okay to ask questions. Like, I don't understand why we need to have this special assessment. Can you better explain to me? But obsessively, coming to every board meeting with 50 questions for the board, that's like over the top. That's not what I'm saying here. But I'm saying you have a right to ask questions, and the board should be responding in a respectful manner if they have the answer right there, or responding in the future. Okay, another obligation, of course, would be, or let's talk a little bit about board member. We just finished rights. So let's talk about what are some obligations you have as an owner. So we just talked about member rights, right? Elect board member, review records, due process for violations where fines are going to be levied, and you have a right to ask questions. Let's talk about what are some member obligations. Some obligations that you have as an owner member would be, you have to follow the documents of the association, right? You have to pay your assessments on time. You got to maintain your home. Otherwise, you're going to be sent violation notices for lack of maintenance. And you also have an obligation to be informed, be apprised about what's going on in your community as a homeowner, so that when the board comes to you to vote on something, you understand the issue and you're ready to vote. Briefly, let's talk about committees. Committees are usually set up via the association's documents. The most common committee that we see are typically going to be like architectural committee or the budget and finance committee. Their role is really to assist the association's board. The architectural committee sometimes, or most of the time, has very specific guidelines that are set up in the CC&Rs in terms of how they should run. Okay, let's talk real quick about the role of the management company. It's complicated, right? There is no perfect management company in Arizona. And I think everybody agrees to that. There's probably no perfect attorney. There's no perfect board. There's no perfect homeowner. And so what we want to do is the management company, you need to make it, clear in as nice a way as possible that, okay, who's the boss? The management company is not the boss of the association. They are an advisor, and they are helping the association make good decisions. Same thing with the attorney. I am your advisor. I'm here to help you and keep you out of trouble. Sometimes we get the management company that oversteps a little bit and says, no, board, you have to do it this way, or, it's the highway. And that's not a good, vibe, in my opinion. So really what you want to do is look for a relationship with the management company where you're working together. You're on the same team. There are going to be times where the management company is going to say, administratively, it's easier for us to handle this way. And as a board, be respectful of that, because you don't want to be the nightmare board that makes them have to spend 10 hours more on something that could be easily automated and they do for everybody else, and it makes sense. But on other things, there may be times where a board may want something different and, talk about it respectfully with the management company and try to come to some common ground to work together. Typically, the management company is going to help with collecting assessments, help with violation letters, creating the first draft and multiple drafts of the budget. They maintain the records for the association. They prepare the minutes for meetings. They typically help you prepare for the annual meeting and do all the paperwork that's needed to provide notice of that, and also your regular board meetings. And they generally handle phone calls and written correspondence to owners. So that is just kind of a good overview of the different key players in the community association industry and what their roles are. I cannot emphasize enough the importance of teamwork and working together with all the different players in our industry. That is how you can transition to become a successful association. And it's a perfect time to transition over what are some qualities of a successful association. So, with the volume of clients that we have, I've worked with a lot of different associations over the years. And what I tried to do is come up with what are the most common things that I see with successful associations, or what's the secret sauce to, help associations operate at their highest level and, get things done, get along, be responsive to their homeowners, have your property be maintained really well. So there's a number of different things that I think contribute to having a successful association. And I can think of, honestly, I can think of like 5 right off the top of my head. Okay, those associations are operating at a high level. The owners are happy. There's no recall meetings of the board. They're fiscally responsible. They don't have lawsuits all over the place. And so let's talk a little bit about what are kind of the most important things that you should be thinking about. Number 1, you have to have a really good team to guide you. Who should be on your team for your board? It's going to be your attorney, your CPA, your reserve company, your management company, your landscaping company. You want to surround yourself with people that have the same values as your organization and who want to help you, who are motivated by creating something bigger. My goal is always to help associations function at a high level, to be successful, to have happy homeowners, to be the association that's accomplishing big things and not getting caught up in a bunch of petty crap and lawsuits and, things that take time and energy away from the big role that you have, which is maintaining and managing your community. Okay, so surround yourself, number 1, with, an outstanding team. Whenever you have a great team, you can accomplish big things, okay? The next thing would be communication. Having good communication as a board is going to solve so many problems for your community. And so what are some examples of good communication? So having a homeowner forum at your regular board meeting and at your annual meeting each year, where you listen to your homeowners. You don't have to give them, 10 minutes each owner. It's, 1 minute an owner. Tell us what's going on. How do you feel about things? Make sure that you are letting owners know about when your board meetings are, following the open meeting law 48 hours in advance, giving them enough detail on that agenda that you're going to have to start giving to them before the board meetings so that they know, starting September 14th, hey, this is what this meeting's going to be about. Do I want to go or do I not want to go? Having a good detailed agenda. Have town hall meetings when things aren't going well. So if you have a serious problem or your board is hearing through the grapevine that, hey, there's a removal petition circulating in our community, that should be a time for you to look in the mirror and say, things aren't going well. And what can we do to improve things? And hopefully the board, if they're in that situation, is reaching out to me to help them. One of the first things I'll suggest is have a town hall meeting, air grievances, answer questions, listen, find out why people are unhappy, and find a way to do better. Talk to your trusted advisors, see what they think. Another great thing to do to build community spirit is have some fun events. Do something for Halloween, do something for the holidays towards the end of the year. Have a 4th of July party, have a donuts and coffee at the park in the morning some Saturday. Try to build community in your association. It's hard in Arizona because we have snowbirds and people aren't always here all, different times of the year. But the associations that have the fewest problems, they build community. Remember, respond to owners in a timely manner. Make sure that your management company is being kind and responding to your owners, so that they don't feel like they're asking a question and it goes, unanswered for months. Have a contact person for the association. So when somebody's upset about something, they have a place to call and be heard. Every once in a while, have a survey of your community and find out how people think things are going. Find out, do you want improvements in your community? Do you think the management company is doing a good job? What do you think about not overseeding this year? And that's a big question that I'm getting right now because we've got overseeding coming up in September, October, and November. Find out what the homeowners want. Because if the board makes a decision on something that's really big, like should we convert the tennis courts to pickleball without getting feedback, I'm going to tell you that it's a recipe for a disaster. So all of this falls under the good communication umbrella. And kind of one last tip would be in contact with your owners frequently, once a month or once every 2 months with a newsletter and email blast, just letting them know what's going on. Have your minutes on your website so that if somebody wants to go back and look at them, they can go right to the website and find all of the approved minutes. So first and most important, secret to being successful is be a good communicator as a board. Another important thing is have strong leadership. For people who are serving on the board, it's important that we have strong leaders. And what are some examples of strong leadership? So, like a sports team or any other profit business, leadership starts at the top, right? And so as a board, you need to emphasize teamwork. You cannot have the board president doing everything and, everybody else on the board just hanging out doing nothing, right? That's going to create, burnout, frankly. And some people may want to be more involved. So as the board president, whoever that person is, you need to be the point guard and get the vibe from your board. Like, how involved do they want to be? How can we divide up responsibilities? How can we work successfully together, especially if you've had problems in the past? Like, I know when I got back on my board, in 2016 again for the second time, I was unhappy with how things were going in our community. So I kind of was persona non grata when I got back on my board. And so it was a good discussion to have with the board, like, hey, I know that I was unhappy with some things and I was, campaigning to be on the board and I, indicated that I felt things weren't running well. I'm here to work together. I love our community and let's find a way to make it better. Okay. And that's a good way if you have differing, opinions on how things should be done on your board. A really good thing to go back to is, why are we here? We're here because we love our home. We're here because we love our community. We're here because we want to help make it better. And if you can always go back to those three things, it's going to make your time on the board better. We may disagree, purple flowers, pink flowers, pickleball versus tennis, whatever the issues are. We may disagree, but we all have those three things in common, right? Another really important thing for strong leadership is having honesty, integrity, and transparency as a board. If your board isn't acting with those three pillars, the owners aren't going to trust you and you're going to have problems. So be transparent. You're not hiding anything. Everything is open for people to see. There's few exceptions that are not open. Being honest, we screwed up. I'm sorry. That was a mistake. And I'm so sorry that you got that violation letter that should have gone to somebody else. And integrity, doing the right thing, treating people the same, and not giving certain people preferential treatment. Okay, a couple things, a strong leadership, just kind of some closing remarks on how to have successful associations. You got to be committed and you got to be determined if you're serving on your board. I would be lying to you if I didn't tell you that I don't think at least once or twice a month that I don't like being on my board and I would like to quit. That thought goes through my mind once or twice a month. Okay, so that I'm just being honest. I'm putting it on the table. Serving on a board, an HOA or condominium board, is hard, right? Sometimes you're not making new friends in the community because you're having to send out violation letters, or you're having a hearing regarding your neighbor's teenager who, did something wrong at the pool. It's I would say more hassles, less fun. But you have to look at the big picture. I am committed to having my home be in a beautiful community. I'm committed to our association being fiscally sound so that it doesn't affect my property values. I'm committed to having maintenance of our association's, common areas so that things look nice. I'm committed to, making sure that we have a reserve so that we have enough money to renovate the pools when they need to be renovated in 2 years or whatever. It's a tough job being on the board, and how to have a successful board. You have to recognize, hey, it's tough being on the board. And when a board member is struggling and you can see they're like kind of, thinking that the I'm going to quit thing is going through their mind, that's a really good time to reach out to them, especially if you're the president, you're the team leader, and say, hey, I get it. You have a lot going on right now, maybe with your business life, your personal life, and we really appreciate you being on the board. Can we take back a few things to help you out, while you're dealing with that? Or, I feel like maybe you are putting in a little too much time on the budget and the whatever financials. Would you like to maybe dial that back and give that to somebody else this year? Because it's been a lot the past 3 years or whatever. So just recognizing that serving on the board, it's a time commitment and it takes determination and commitment. And everybody's thinking this isn't easy. And you just need to know that going through. But the overall goal of making sure that your community is doing well and being successful and well maintained, really, whenever I do the balancing test, I always balance it to stay on the board because I want our community to be a great community. And it's going to really bother me if I get off the board and the community starts to falter and, not look nice and not do well. And trust me, I was off my board for a decade. So I saw it firsthand how frustrating it was to see things disintegrate that I had worked really hard to implement in our communities. So, really a couple just closing points on, being successful with your associations. Communicate with your owners, really important. Have strong leadership. Even if your board is, not always getting along on things, try to go back to those 3 common goals that you have for your community and recognize, lastly, it's hard to be on the board. You need commitment and determination to, stay on the board and to continue to get things done. Some things are hard to do right now. My community really needs to set up, like a long-term planning tool for our community. And we're 50 years old, and it's hard to get the votes to get it done. But I am committed and determined to stick it out until we get those votes so that we can start getting our community on a better plan. So that we can maintain some of these 50-year-old things that are, now disintegrating and needing to be, either removed or completed or whatever, updated, repurposed. It's hard, but I'm committed and determined to do it because I want what's best for our community. Okay, so we had a great class today. I'm about 7 minutes over. I'm sorry, but we spent a lot of time on the new legislation, so I hope you'll forgive me. We have a number of questions here today, which is amazing. It looks like right now, I'm just doing a quick little count here. It looks like we have about 36 questions. So I'm going to just get right into the questions. Question number 1 is from a board member. Several new 2024 laws override communities' documents. Could you provide recommendations for notifying owners of such laws? Are there alternatives in lieu of amending documents which incur legal expense and require 67% approval? For example, the interior modifications for condominiums, House Bill 2141, overrides a CC&R article which requires carpeting in certain areas of second floor units. So really great question. So I think what I would do is, we have a wide variety of laws this year, right? And I think what your association needs to do is take a look at which laws you think will most impact your community. And I think I would talk about them in a board meeting. You might even want to write a newsletter article about them in your newsletter and, talk about the implication of the new law and what does this mean for our community. And maybe you want to get your legal counsel involved to help you write that article. You may also want to talk with your legal counsel about, do we need to make amendments to our CC&Rs to make our CC&Rs consistent with what state law says? Okay, next question from a board member. Can a board member conduct meetings in their private residence? So short answer would be yes. I have seen that. Many boards, have their board meetings in public places. Some of them have them in private, you know, um, maybe in their clubhouse or maybe at the pool or something, private areas, but they're not private residence. But I also see some board members opening up their home to have it in private residence. It's probably not best to do it that way because sometimes meetings can get a little feisty. Um, it works for some associations, but it doesn't work for others. Question number 3. I want to know if there is an Arizona law that requires an HOA to have an online bulletin board where both HOA and members can post info and responses to postings. Our HOA uses the management company's bulletin board, but doesn't have capability for members to post responses to any HOA postings. Is there a law? There are some members in the community who are saying there is a requirement for this. What they told me was House Bill 2158 did this. Go back and look at which one is House Bill 2158. Maybe my office can pull that up for me because I think we removed the numbers now. I mean, I'm not aware of any law that, says that you have to have an online bulletin board where there can be open dialogue between the HOA and members. I think maybe what you're asking about is, is the posting of the agenda something that requires us to, have this online bulletin board and advance the meeting? I don't think so. But I'll circle back on this question at the end. My office is going to pull up House Bill 2158 for me. And I'll go back at the end and we'll answer this question again. Okay, next question from a board member. Does an HOA board have a fiduciary obligation to pass a balanced annual operating budget? If, for example, in 2024, the board votes to increase operating expenses, but not to increase offsetting assessment increases, and if the year-end budget is in deficit, is the board obligated to follow January 2025 to balance the prior year's deficit with a suitable assessment increase? So great question. I'm getting this question actually twice in the past month. So this is a great question for all of us to talk about. So I really do think you have a fiduciary obligation to act in the best interest of the community, right? And like anything in business, if you're spending more than you have in your wallet, that's not a good thing, right? And that, in my opinion, is considered a breach of fiduciary duty. So there are some times, though, where your board has no control over this. So let's give 2 examples. So if you're setting your 2025 budget, you should be setting it to zero out, meaning the amount of income should, equal the amount of your expenses. Okay. So just so we're clear on that, like you don't want to set yourself up for failure on that. In terms of if you're in the middle of 2024 and, maybe you had some expenses that are getting you off budget, and this happens all the time. Like maybe you got involved in a lawsuit or your electric bills are really high or your water bills are really high and they're way over budget and you're having trouble balancing your budget because you're way over budget. I mean, that does happen. It happens probably in every association at some point during the year. In that case, you have to look at, can we skimp on something else? Like, can we not do something just to balance that budget in 2024? Like maybe we were planning on putting in new tennis nets at the tennis courts. Now we're not going to be able to do that this year because, the water bill was so much higher. I mean, that type of discussion's happening in associations all the time. Occasionally, we'll see an association that's way over budget, and they'll say, can we borrow from the reserve to balance the budget? Talk to your CPA about that. In some cases, you do that, but then you have to pay it back. So I hope that answers your question. I mean, there's no perfect answer on this, but you should be trying to balance your budget. That's something that should be analyzed every month, and definitely when you're planning it for 2025. You want to set yourself up for success by balancing the budget. Okay, next question. What happens to an HOA and its homes when the HOA goes, meaning it can't afford its bills? I think what you're meaning is like, what happens if you go into a receivership, right? Or maybe the HOA just dissolves or something because they can't afford their bills. I mean, it's not a good situation, and it's not something that actually really happens very often because you can't just let the association go. There's an obligation of the board to maintain the common areas. The city's not going to want the property back. If you try to dissolve it, the city very likely is not going to accept the common areas back because it's pursuant to the contract, the association, it has to maintain the common areas. So what happens to an HOA? It doesn't happen very often if the HOA, totally evaporates or become defunct. As a matter of fact, I can't think of one time in 25 years where I've seen that. I have seen associations have to go into a receivership, and it's sad when that happens, and it's very expensive. But the receiver typically will get things back on track. But usually what happens is people step up to help. The helpers come out and they, find a way to get things back on track. Next question, number 6. A growing group of owners are concerned about the fact that the number of rental properties has been gradually increasing. Currently, rentals are just over a third of the units. Would it be wise to redo our documents? And what would that look like legally and financially? We have a great cheat sheet on this topic called Amending CC&Rs and Implementing Rental Restrictions. I would recommend that you take a look at that. You can find that on our website at mulcahylawfirm.com. Doing CC&R amendments, in this post-Callaway time. So Callaway was a case that was decided by the Supreme Court of Arizona several years ago. Makes it a little more difficult for us to amend documents. If the amendments were not foreseeable and they aren't considered reasonable. I think what I would recommend is for you to reach out to our firm. We can take a look at your documents, figure out whether or not you have the votes to implement a rental restriction, and a pivot if you don't, because it sounds like you already have a third of the units. I don't know how much it takes to amend your CC&Rs. Maybe we come up with something that's kind of creative, like we grandfather all existing owners and make the, no renting apply only to new owners. Check out our cheat sheet. We give you a bunch of different suggestions on how to do that, and reach out to our firm so that we can help you with that. Next question, number 7. Can the due date for ballots being returned be 2 days after the special meeting is called? Special meeting is called for September 24th, and the ballots are not due until September 26th. That's unusual. So you're having your meeting and the ballots aren't due until later. I'd have to see the context of it, because is this the type of a vote where, I can see how this could be coming down. Like I could see that maybe you're going to talk about the issue as a community at the meeting, and then, they have to have their ballots back 2 days later. Is this the type of thing that requires a vote, in conjunction with a meeting? If it is, then having it due 2 days later may not work. So I don't know enough about this. Sometimes you don't need a meeting as membership for a vote, and I don't know what the special meeting vote is about. So it's hard for me to answer it, but it could be potentially okay, but I'm leaning more towards no, you really should be doing it the same day as the meeting. Now, if it's a CC&R amendment, you could extend that out past the meeting, because most of the time you don't have to have a meeting. So I don't know what the vote's about, so it's hard for me to comment, but it could be okay in certain circumstances. Okay, next question, number 8. If we have a security camera policy and post signs to notify residents they are being recorded, is there any reason we cannot have security cameras monitor the common area pool and pool deck? I don't think so. I think that this should be fine. Run the policy and the signage by your legal counsel to make sure that, they are okay with the language. Next question, number 9. Where does Sun City West get authority to regulate? For instance, if you can divide your house into 2 different rentals, no HOA. I'm familiar with Sun City West. I've been out there many, many times to teach classes, and I represent a number of the associations. At one point, I was legal counsel on a certain issue out at Sun City West. I would say short answer would be they get authority to regulate based upon the recorded documents that apply to the lots or units. I don't know what you mean by if you can divide your house into 2 different rentals and no HOA. I don't know enough about that to even comment about that. That sounds very unusual, and it doesn't sound right. So I'm not going to comment on that. I am aware that there is a large master planned association out there, and they do have documents. Question 10, our board meetings go on for too long. I think implementing a time limit for comments and questions would make a huge difference. Do you have experience doing this without making people feeling like their questions were not answered? So we have a great cheat sheet on community association board meetings that I would really recommend that you take a look at. We also have videos on our website called How to Have a Board Meeting in an Hour or Less. So 100% you should be implementing time limitations if your meetings are over an hour. Just really the nice way to do it is to have the president say at the beginning of the meeting, hey, our meetings are going too long, and so we're going to try something new this month. If any owner wants to comment, they need to comment during the homeowner forum at the beginning of the meeting. Each owner gets 1 or 2 minutes, whatever you say, to comment. And then when we open the board meeting, it's only the board talking. The only time an owner can make a comment is before the board takes formal action on something. And at that time, you get 30 seconds to make a comment. And just be really nice and give people a little warning. If they're at 30 seconds, say, okay, it's 30 seconds, you need to just finish up in the next 10 seconds. Or if, they're at 2 minutes, just say, okay, you're at 1 minute 45, you have 15 seconds. Let's tie it up right now. I think people get it. And I think most people like to have a time constraint because it helps them, formulate their feelings on something and give their opinion quickly versus just talking and talking and talking with no end in sight. Check out our cheat sheet. We have some very good suggestions in that cheat sheet on how to have a successful board meeting. I think we may even have another cheat sheet called How to Have a Successful Board Meeting. So you might want to look at that one too. Okay, question number 11 from a board member. CCNRs state that owners are responsible for damage and repairs to the roof. The storm damaged 23 of 44 roofs. I objected to our HOA funds to repair the roofs as this is a contradiction of the above CCNR. Our chairman said in this situation, the insurance company dictates we do. We have a $2,500 deductible. The repairs are over $3,000. The chairman said we will not go through the insurance company and pay all repair. We will not go through the insurance company and pay all repairs out of the HOA funds. I feel this is a misuse of HOA funds because we are not involving the insurance. My question would be, is a board required to follow the CCNRs, which require or stipulate that homeowners are to pay for repair and replacement? Well, I don't have your CCNR, so I don't really know, what they specifically say. And I don't know if you're a condo or a planned community. It's hard for me to comment on this because, one thing that I would look at is, okay, if you have a deductible that's close to what it's going to cost to repair, you may not want to make that insurance claim. That's something, a business choice that your board may be making. And, I'd have to hear all the facts, but that could be the right business choice. Generally speaking, your board does need to follow the association's CCNRs, but I don't know what your CCNRs say on maintenance of these roofs, et cetera. Okay, question number 12. Should a board member who does not comply with filing the board information on Corporate Transparency Act, should they be removed until they comply? Well, there's really nothing under Arizona law that would allow us to remove them. It's a sticky situation. I would just file what you can based upon what the board members are willing to give and see if it gets rejected or see what happens. If I had to guess, it probably will not get rejected. They might send a follow-up response back and we'll have to see what that says because this program is so new. But they can't be removed from the board for not complying with the Corporate Transparency Act. That's just not in your documents and it's not consistent with state law. And I'm not really sure I would even suggest that this type of person who doesn't comply should be removed from the board. I think this problem is going to go away. I don't think in 2026 and beyond, we're going to have to file this Corporate Transparency Act, but I do think we have to file it for this year. Okay, question number 13. We have an election coming up soon and only one candidate to replace 5 board members who are not running for re-election. Our CCNRs allow for a board of 1 to 9 persons, but obviously it's not feasible just to have one person. What should we do? Okay, you have a lot of people, getting off the board and you only have one person willing to run. We send out a letter to associations that have this problem. We send it out to the entire membership. We write it and then the board sends it out by email typically. And we just let them know, hey, this is what happens if we don't have a board to run the community. It's possible that a receiver could be appointed to run the affairs of the association, and that's going to cost a lot of money for your community. Whenever we send that letter, typically people volunteer. So you want to reach out to us and have us help you with that. Question number 14, our association president believes that by calling a meeting with a majority of the board members a committee meeting, that she does not have to notify the owners of the Zoom information, provide a detailed agenda, or produce minutes. Is this true? No, that is not true. If you have a quorum of the board meeting to discuss association business, even if it's in a committee meeting, it's considered an open board meeting. You need to fully comply with the open meeting law. Question number 15, we are in need of help. We have a board president who is becoming worse. She is a dictator. She now has issued cease and desist letters to a board member and another community member. Neither has done any rule breaking, but they have raised questions and the president is angry. Her and our property manager accept info from no one. Mute people if they don't like what they say. Our community is at odds. What do we do? So it sounds like maybe you're a homeowner in your community and you maybe have a board member who is, a dictator, it sounds like, right? So what are some things you can do? I mean, you can get a petition going to remove the director from office, the board president. That would be a way to get her attention. You can, come to a board meeting, have all of you who are upset about this come to a board meeting and express concerns. You could write a letter expressing concerns. You can run for the board yourself. That's something you definitely can do. You can go to the Arizona Department of Real Estate and file a claim if you feel that the president is not following the documents or exceeding her corporate authority. You file a lawsuit. You can get a lawyer to help you write a letter with your concerns to properly articulate from a legal perspective why the president is engaging in, violating the law or not being reasonable. Lots of different suggestions for you on that. I'm sorry that that's happening. The best thing you can do is get involved, I think. Get on the board yourself. Try to make positive change. Okay, next question. Arizona Revised Statutes 33-1808 allows associations to limit the display of political signs on a residential property to no more than 9 square feet. This limit is mentioned in our association rules, and flags are treated as signs. A homeowner is using his golf cart as a platform to display 2 large political flags, with each flag measuring 15 square feet, draped over the back and side of the golf cart. The homeowner conspicuously parks the golf cart in the driveway during the day and returns it to the garage at night. The association has received numerous complaints. The homeowner likely will argue his flags are akin to bumper stickers to circumvent the political signage restriction. However, the board believes the statute's signage restriction applies in this case. Using the Arizona Revised Statutes square footage speculation as justification, is the board correct in requiring the homeowner to remove the flags? So short answer would be yes. It appears that, the flags exceed the signage maximum that's allowable under Arizona law for planned communities. I don't know, we're in August and the presidential election, I'm assuming this is regarding the presidential election, is in November. I just don't know how far you want to take this. I do think this sounds like a pretty egregious situation. I probably, if I were advising you, I would say pick up the phone, call the owner, maybe have your attorney pick up the phone, call the owner, talk about it with them and just let them know that they're beyond the sign, maximum. And see if we can kind of come to a resolution on this, maybe a smaller flag that meets the, no more than 9 square feet. If the homeowner won't comply, you have to kind of weigh how long is it going to take to, we can send a letter to the owner and then they'll probably have a response. Maybe they hire an attorney and, we're not going to be able to file a lawsuit and get a ruling on this. We're not going to be able to get a ruling with the Arizona Department of Real Estate by, the second week in November, or whatever, first Tuesday in November. So, we have to be a little practical here. Hopefully we can make this resolved with a phone call or maybe a demand letter. But these are complicated issues right now. It's a complicated time in our country and we're seeing more and more questions on political signs. It's a sign of the times, so to speak, no pun intended. So I think I gave you some good suggestions on how you may want to handle that. Okay, question 17. Why does a president or board members of an HOA have to report BOIR for CTA if a management company handles all the funds? Well, great question. It's because the law says you do. That's the way they set up the law, and they're trying to, avert terrorist activities and they're asking for that information. Is it ridiculous? Absolutely. Is it upsetting? Absolutely. I'm a board member too. I have to give all my information too. But the way I'm kind of looking at it is the government already has all this information on me already. And, it's nothing new. It's new that I'm a board member in my association, and the information about me is nothing new and I have nothing to hide. I'm obviously not involved in any of the activities that they're trying to, avert. So, okay, next question, 18. Our board just announced they're providing, for a friendly reason, pool keys residents of a nearby HOA during a month or so while their HOA pool is being renovated. There was no notice to residents of a board meeting to make this decision, just an announcement. Do you and your professional advice see liability risks that our HOA residents could be exposed to? Is this a financially and prudent decision by our board? Honestly, I wouldn't be in favor of that. I would have to hear more in terms of the justification on this, but I don't like that in terms of, it could cause overuse, and it could take away the amenity from our current residents. What sort of liability do we have if there's accidents? How do we get that pool key back after their pool is, renovated? Do we have to now rekey our entire community? And there's a lot more problems there than I would say benefits. Question number 19, if the board is having an executive session, is an agenda required to be posted with the meeting notice to the community? So yes, I would recommend best practices would be to provide the agenda. Now remember, several years ago, the law was passed that said that anytime we go into an executive session, we have to state with particularity which sections under the law, executive session law, we're going into executive session to discuss. So you're probably already doing this. So I would recommend that you just post the agenda along with the meeting notice and cite the sections in the statute that you're complying with. Question number 20, our HOA has a regularly scheduled architectural committee meeting each month. Does the meeting have to be notified each month with an agenda 48 hours in advance, or can it be announced for the whole year with a general agenda? I would recommend, so you do have to give the 48 hours notice, right? Let me go back up and look at that agenda law real quick again. I think there was a caveat that it was only for board meetings. Let me just see. It's only for every board meeting. So I think, if we're going to read that, it's, regular board meetings and executive session meetings. Now, best practices would be, in my opinion, to also give it for the committee meetings. But the way that the law is worded, I don't think you have to do it for the committee meetings, because it doesn't say board meetings and regularly scheduled committee meetings. But that being said, I would still consider doing it anyways, because it's easy and it just shows transparency. So I would do it. Okay, but let's see another thing here. Okay, so question, you do have to have an agenda though at the meeting. Just so you know, that's something that is for any board meeting or a committee meeting. I think that's important. And honestly, for the architectural meetings, I think it's a good idea to have the agenda too and list which properties are, there's a change up with, because if it's a neighbor, they may be interested and you don't want them coming back later and saying, well, I didn't know my neighbor was putting a second story addition on the property. Okay, question number 21. It is assumed that if a board member refuses to provide their personal information as required by the new law, they must resign their position. I'm getting a lot of questions on this in the Corporate Transparency Act. So, you can request that, but I don't think that they have to. So I'm starting to see this more and more. This is like the third or fourth question today on this. So I don't think you can assume that they must resign their position. They don't have, that's not something that's required. I do think on that flip side of that it's not that big of a deal to provide it. So I would recommend that everybody who is a board member, should be complying with the Corporate Transparency Act requirements. Now, if they don't want to, of course, they may say, I don't want the hassle, I'm going to quit. That's fine. That's their prerogative. Question 22, what rights does a community have if they have a green space easement with SRP and want to add amenities to that area? Is the community responsible for the property taxes of this, or is SRP? So I'd have to look at your plat map to see exactly how the, green space is set up. So it's hard for me to comment on it, but I have to look at your documents. I think that's probably the best thing I should say. And I've really never seen anybody building amenities in green space in 25 years. So, there may be prohibitions on it on the plat map, et cetera. Next question, 23. Can a management company tell the board that community managers are in place to manage and enforce compliance and violations of the CC&Rs, and that the interference of the board trying to micromanage that process over the community manager is counterproductive and is creating issues for all? Can the community manager tell them to stand down or do that part of the compliance themselves if they won't? To me, that sounds like there's a little dysfunction going on between your board and the management company. I mean, I don't like to hear this. Again, we got to go back to what I said earlier in the presentation, that we're all a team, right? And as part of our relationship as team members, we should be able to work together and communicate together. Now, yes, generally speaking, I would agree that managers, that's their job to manage and enforce compliance. But as a board member myself, I can say that sometimes the manager isn't catching things that I'm seeing. So I do email the manager, hey, take a look at this, or I saw these violations. Here's the pictures. Please go out and take a peek at them. I don't think that's micromanaging. I think that's just being proactive, and I'm doing, what I'm supposed to be doing under my fiduciary responsibilities. Now, that being said, I'm not out patrolling, the neighborhood every night with my camera looking for violations. Big difference. I'd see a violation that's like, okay, yeah, I can't overlook that. As a board member, I snap a picture of it and I send it to my manager. Maybe once or twice a month, maybe. Some months I don't even see anything that would be worthy of doing that. So I think there's a balance there. I think maybe you might want to consider having a boot camp with our firm to talk about the issues with your management company, because it sounds like things are going in a dysfunctional direction. Okay, question number 26. I'm just going to do a quick question to see how many. We're getting a lot more questions, 44 questions. So next question. We are a new association in Buckeye. I have been attending your classes. How hard is it to change to your law firm? Oh, that's a good question. It's very easy. So really, you just need to have a majority of your board vote to hire your new attorney. And you just sign the agreement, representation agreement, and we're working together. Okay, question 25. If CC&Rs do not allow, do we have to allow? It depends on how it's worded. If it's very clear, like sheds are prohibited, then you should not be allowing sheds. Now, there's some, exceptions to that. Like, let's say somebody put a shed in 10 years ago and we didn't do anything about it. We may be prohibited under waiver latches from enforcing it. So we have to look at it on a case-by-case basis. Okay, 26. When a homeowner is cited with a violation within a surveilled area and requests to review the video evidence, is the association obligated to share the video? I would say, if it's a book and record, then you've kept it. Yes, I think it should be provided to the person that's requesting it. 27, if someone is running an Airbnb in our condo community and it's prohibited in the CC&Rs, is there a limit to the fine that can be assessed? So no, just the fine under Arizona law says it has to be reasonable. And I typically say that, you probably want to charge the fine or levy the fine in the same amount of money that the rent is, so that they, I think that's reasonable in light of the fact that they're getting the benefit of maybe $500 a night. Maybe the rent needs, or maybe the fine needs to be in that neighborhood. Question 28. What happens when a committee is formed by the board, however, does not listen to the committee? I wonder if they mean to the board. Okay, so what happens? Oh, so maybe the board's not listening to the committee. Okay, so board creates a committee. And then the committee provides information to the board and they don't want to hear it, or they don't want to listen to it, or they don't like what they're being told. I mean, ultimately, that's how things work sometimes, and so the board chartered the committee to do certain things. The committee reported back. The board doesn't have to follow exactly what the committee says. They can just take the information in and make their own decision. I mean, obviously, if the committee, did a good job and they're making good choices, the board really needs to seriously consider what the committee is saying. Next question, 29. Can a master association delegate their enforcement duty to sub-associations? Yes, I see that in documents from time to time. It really should be in the CC&Rs that they're doing that. Question 30, how do we obtain quorum for annual meetings? We do not reach quorum. We did not reach quorum last year and have already had to reschedule our annual meeting for this year because we didn't have a quorum. So we have a great cheat sheet that covers this topic exactly. It's called Annual Meetings, and some quick suggestions on how to get a quorum. Put something controversial on the agenda and people will come. Like a special assessment or increasing the assessments or change of use of the common areas, something that's going to people be interested in. Invite a guest speaker, make it a social event with free, cookies and lemonade or whatever. Make it at a time that's convenient for everybody. Give people an opportunity to appear by Zoom if they can't be there in person. I mean, there's all kinds of different suggestions that we put on our cheat sheet that you should take a look at. Okay, what happens? Question 31, when the questions asked are obsessive, how does the board deal with this? I'm laughing just because I see it so often, so I have to give you a little chuckle there. Well, when somebody gets obsessive, that's usually the best time to give the person to your attorney to manage them, because you might be dealing with like a mental illness or something, and it's unfair to stick that person on the management company. Our firm is very well equipped to handle those type of situations. We have a lot of obsessive owners that, we have a little plan that we follow with them, get them back on track. And if you provide us with that person's information, we will get them moving in the right direction. Mainly, we're friendly and cordial, but we're firm. Like if you have questions, this is how you are going to be answering them, how you're going to be sending them to me going forward. And, I set up a method for them to communicate with me that prohibits them from, emailing me 50 times a day. You can send me one email a week with your questions. Recognize that we, are not required under the law to answer every question. We are required to respond to records requests. And I just try to be nice. And usually what I do when I get one of those people is I ask for a phone call and I ask them, what's going on here? What are you so upset about? And we try to talk through the issues and try to get them on the same page as the board. Next question, 32, we're planning our budget. Is the Open Meeting Act applicable to board meeting to plan next year's budget and bound to give notice to HOA members? The budget is not a reason for an executive session. That is true. So anytime you have a quorum of the board discussing next year's budget, it should be an open meeting. If you don't want it to be an open meeting, only have less than a quorum meeting. Question 33, can a husband and wife serve on a board as two directors? My team we're all laughing because we're all sending notes through, we're all looking at the same questions at the same time. And we say it's our favorite question. So we do get this question often. So generally speaking, yes, unless the bylaws prohibit it. Is it a good idea? No. For various obvious reasons. It gives too much power to one household. It's just not a healthy thing to have, and we do not ever encourage it. Question number 34. What happens when a unanimous consent for board action in lieu of a board meeting fails to get all board members' signatures? Does the subject fail and cannot be brought up again, or what happens? Or does the subject go to a regular or special board meeting for action by the board? So, if it fails, it fails. You can reintroduce it at a board meeting in the future. But I think the bigger question is you really shouldn't even be doing the unanimous consent for board action because I think those violate the open meeting law. What should be included in meeting minutes? So I have a great cheat sheet on board meetings. On the flip side of it says how to take perfectly proper meeting minutes. So take a look at that. The key thing is 30,000 foot view of this is the minutes should reflect what was decided. It shouldn't be a word for word diatribe of everything that was discussed. It's big. The decisions that are made at the meeting should be reflected in the minutes. Minutes should be like 1 page, maximum 1.5 pages. Next question, 36. If an AC or landscape request is denied, should the board explain the reason they denied the request? I don't think you're required to explain the reason, but it's a nice thing to do to have transparency and to make the homeowner feel like they were heard and to have an explanation why it didn't work and what they might be able to do to make it, do something that would get approved. Next question, 37. How do you balance deferring to the management company, if you have one, versus the board taking the lead in decision-making and strategic planning for the community? Here's some context. Some board members and community managers view the management company as the expert and prefer to defer all decision-making to the management company. I mean, I think it's just like a balancing act. So, I mean, I would not defer all decision-making to the management company because that's borderline breaching your fiduciary responsibility to your community. I think the key thing to look at is here, when you're serving on your board, if you have an expertise and you can help the board, let them know, why you have the expertise. Like, hey, I've been a structural engineer for 50 years, and that wall doesn't look like it's being built right. Or like in my case, I'm not the legal counsel for my association because I can't, do that because it would be self-dealing. But I can look at an issue and be like, okay, I feel based upon my expertise that maybe we need to manage this lawsuit a little differently. But I think that's totally fine. You just have to balance it. Is this person really an expert? Are they really helping? You have to have a majority of the board agree, before you can, move forward with, like strategic planning. But I mean, I wish more boards were talking about strategic planning. And if somebody has some experience doing that, by all means, I think they should be helping the community. If they don't have experience and they go to a class on it, that's okay. Get some experience and then come back to the board with your suggestions. Okay, next question. What are options for community that is having challenges obtaining community insurance due to their claims history? Coverage that is required by the governing documents as well as by lenders for any potential buyers or sellers in a condo community. So if you can't get insurance, what are our options? Pay a higher deductible, go into the high risk insurance market. I mean, it's really not an option to not have insurance. So if you're in this situation, reach out to our firm. We can definitely help you navigate this. We've helped other associations many times, dig out of an insurance problem where they can't get insurance before. Next question, 39. Our community is a 50-year-old community, and our board is attempting to set up long-term plans, but have a lot of resistance, especially from our older members. I'm laughing because I feel like this is my association. How do you convince those people that it's in their best interest, as well as being best for the overall community and for property values? I mean, I think you have to bring in a team of experts to provide the information to the membership. So there's some long-range planning companies that are out there that come up with 5-year, 10-year plans that are amazing. They come in and do a study of your association, including a survey, and that, gives you feedback how many people in the community want the changes, et cetera. For the older members, you can just provide the evidence to them. Like, here's the realtor's, opinion about property values that would go up if we redid our 4 pools. And here's the 5-year plan from the company that does strategic planning. I mean, ultimately give them as much information as you can, but recognize that sometimes people are just stuck in their ways and they don't want change, and we're not going to be able to get their vote until they move or until they move on. Next question, 40. A community member is accusing board members via social media of taking kickbacks from vendors. How would you advise to handle this? I would have your attorney send a letter to that community member, demanding a retraction, and, reminding them of, what the defamation laws are in Arizona. Question 41, how do we avoid embezzlement? I have a great cheat sheet on this. And I also have a number of classes that I've taught on our website under helpful videos at mulcahylawfirm.com. So we give you a whole bunch of suggestions. So I really encourage you to take a look at that cheat sheet. I mean, I have it right on there. Like, here are the things, here's what fraud and embezzlement looks like, and here's what you can do to prevent that. And I think we're sharing that with you here now as well. Question 42, what is required for minutes? Are they obligated to record details of discussions of agenda items, or just note, report, or discussion took place? Should minutes be more detailed than the agenda? So again, as I said a few minutes ago, the minutes should reflect what was decided by the board. Do we have to record details of discussions? No. I think you do have to report, though, that a discussion took place. You could say, like, we discussed, the board and several community members discussed putting umbrellas at the pool. I mean, that's enough. I think you don't want to have the pros and cons of umbrellas at the pool. You don't need that. Should minutes be more detailed than the agenda? Yes. You have to fill in the gaps from the agenda. The agenda is typically just a sentence or a word, new business, old business, whatever. You have to fill it in with anything that was decided. Question number 43. Residents have expressed concern over a resident who seems to have an alcohol problem. He recently damaged community property while driving. Residents are worried he may cause harm to himself or others. What is the HOA's obligation to take action, and what can we do without violating his privacy? Well, I think I would do a police report for sure on the damage to the community property so that the police, are involved. I think that I would have your attorney send him a letter. I don't know if this resident has family members that live there, but it might be something where we reach out in person or by phone to talk to the family members, about the situation. These are always difficult situations. Reach out to our firm. We've had situations like this before, and I think I can give you some good suggestions. Question number 44. What do we do if our property manager altered the minutes of our meeting? Can we rewrite them to reflect what actually happened? So far, we did not accept the minutes. So absolutely, the board makes a decision on what goes in the final minutes and majority rules. Question 45. What are the rules for using reserve funds? We have a great cheat sheet on the topic of reserve funds. We also have videos that I've taught on our website, mulcahylawfirm.com, where those videos are the main topic is reserve funds, and our cheat sheet is one of our best cheat sheets on reserve funds. You can find both of those on our website at mulcahylawfirm.com. Basically, what are the rules for using reserve funds? I mean, you want to talk to your CPA about this, but you should really only use reserve funds for the items that are listed in your actual reserve study. Okay, I'm circling back now to the one question kind of towards the beginning, House Bill 2158. The question was, do we have to have a online bulletin board where both HOAs and members can post responses? So basically what this says, let's see, so this is a law from last year, the House Bill 2158, where it's talking about peaceful assembly. So basically how this works is if a group wants to meet in the common areas of the association, they certainly have the right to do that. The board cannot prohibit it. If the owners that are meeting in the common areas of the association for their peaceful assembly want to publish, or have the board post something about the meeting, the board has to allow that on the bulletin board. So, but this doesn't require, there is no law that says that there has to be a bulletin board. Basically, if this group in your community wants to have a meeting, a peaceful assembly meeting, and they want the notice to be put up by the board regarding the peaceful assembly meeting, the board has to allow you to do that. Okay, we had a big, long class today. Sorry, but a lot of topics to cover. I think we had a great overview of the new legislation. We talked about what is a community association, what are the differences between associations, what are the documents. We talked about how to be a successful association, and we got through 45 questions, which is pretty amazing. So just keeping you posted on our future classes. We have our next live virtual First Friday event, and that is going to be coming up here on Friday, September 6th at 9 a.m. That's going to be our last chance to talk about the new legislation before all these bills go into effect, so make sure you show up for that. We also have class number 9, the ABCs of enforcement for HOAs and condos. We're going to be talking about lawsuits, how to enforce via lawsuit, how to enforce via the attorney, fining, how to enforce using the Arizona Department of Real Estate. And we're going to be teaching that class on enforcing your documents on Tuesday, September 17th at 11 a.m. We also have 2 opportunities in September and October with the city of Scottsdale through their neighborhood college. We're going to be teaching those 2 classes in person versus the online classes that I just talked about. The first one's going to be on Monday, September 16th from 1 to 3 p.m. We're going to be talking about Finances 101 for associations and how to prevent fraud and theft of association funds. We're also going to be talking a little bit about the legislative update, because it'll be 2 days after the new legislation just took effect. And then we're going to be teaching another class for the city of Scottsdale on October 7th from 1 to 3 p.m., again in person, how to work effectively with management companies. Lastly, just we would ask if you wouldn't mind, if consider leaving our firm a review on Google and or Yelp. It helps us provide feedback for how we're doing in these classes. If you'd like to see more classes, That's one way that you can really help us by giving us a review on Google or Yelp. And we're sharing a link in the chat on how to leave a review. We are always happy to get your feedback. We want to teach classes that are informative and that are helpful to all of you so that you have successful associations. And we, of course, always want to improve our service too. So take care, everybody. Have a great rest of August. Happy Labor Day a little bit early. And I look forward to seeing you for First Fridays in September. Take care. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.